Alright, welcome back to another episode of the Law Schoolers Podcast. In this episode, we are talking about Miranda warnings. We're still focusing on interrogations. In our last episode, we talked about confessions and how confessions cannot be coerced. They must be voluntary. I do want to say that Miranda warnings are completely, well, they're related, but completely different standards, and so they should not be confused. A Miranda warning, as you know, or ought to know, is you need to have, officers need to tell a potential defendant of their rights, the right to remain silent, and then also their right to counsel. And they need to do this before any interrogation is going to take place. If an officer gives the Miranda rights, they can properly Mirandize somebody. They can, if they engage in other actions, promises or threats or physical abuse and deprivations or telling lies, that takes a confession involuntarily, well then, even though they're properly Mirandized, the evidence may still be excluded because it wasn't a voluntary confession. So, related, because they're still talking about the Fifth Amendment, but different standards, because you can still properly Mirandize somebody and the evidence is going to be out. Or you could get a good, valid, voluntary confession, but without a Miranda warning, that evidence is still going to be out. Okay, just a little bit of background info. Let's actually talk about how Miranda came about besides Miranda. So we need to go over a couple of cases to see where our right to remain silent and our right to counsel really comes from. Well, we have two background cases, Messiah versus United States and then Escobedo versus Illinois. Well, in Messiah, what happened is that the officers had placed a radio transmitter in the car of a friend who was acting with the police, and that friend was a friend of Messiah, and the purpose was to gain additional evidence on the defendant. That information was obtained, and this information was obtained after Messiah had already had counsel appointed, and this was something that was a violation of the Sixth Amendment, because the testimony was not coerced, but it was a violation of the Sixth Amendment because he had a right to counsel post-indictment. He had been indicted here. He had that right to counsel, and that right to counsel had been infringed on. So that was a violation of the Sixth Amendment. I want to emphasize that it's a violation of the Sixth. Then we have Escobedo versus Illinois. Escobedo was prevented from consulting with his attorney as he was being interrogated. Another defendant was sent into the interrogation room to confront Escobedo about the crime, and Escobedo confessed. Again, this was a violation of the Sixth Amendment. This was a pre-indictment questioning, not post-indictment, but it was a violation of the Sixth Amendment because the defendant was in a critical stage of the prosecution process. So with this background before Miranda, both these cases came before Miranda. Miranda was teed up to be a Sixth Amendment decision instead of a Fifth Amendment decision. And what kind of impact would that have had Miranda been a Sixth Amendment protection? Well, Miranda is often seen as a very, very protective case against for defendants, but it could have been more protective. If it was a Sixth Amendment protection, everything related to police activity is likely to be tossed out. That was not the case here. Instead, we have the actual case of Miranda versus Arizona. Well, what is our rule of Miranda versus Arizona? Well, the prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. Prior to any questions, the person must be warned that he has the right to remain silent, that any statement he does make may be used as evidence against him, and that he has the right has a right to the presence of an attorney, either retained or appointed. This basis is on the Fifth Amendment, not the Sixth Amendment. So what is the analysis that the court provides here? Well, the court begins by describing the several techniques utilized by the police during interrogations, which encourages the police to talk to the subject as if the subject is guilty already, and until proven guilty is not the case in the interrogation room. And the officers are also working to discourage the subject from invoking their rights. That was the situation before Miranda had happened. So let's talk about these rights in Miranda. Let's start with the right to remain silent. It is important to inform the individual who may not know their rights, and this is an absolute prerequisite to overcome any inherent pressures from the interrogation atmosphere. Let's talk about anything you say may or can rather be used against you. Because you have the right to remain silent, this part of the instruction informs the subject that any further speech may harm the subject. In other words, it's telling them the consequences of failing to remain silent. Let's talk about the next part of it, the right to consult and have an attorney present. This is the right where a subject has an advocate, some additional support system next to them. Additionally, an attorney present may stop any police coercion and providing counsel during the questioning, and to testify if any coercion actually occurs. And then finally, the last part of the rights that officers need to tell these subjects is the right to have an attorney provided if they are unable to afford one. This right is necessary because the vast majority of people who are subject to police interrogations can't afford an attorney, and so they need to be told that they will have an attorney provided if they can't afford one. If the subject, meaning the defendant, invokes their rights, the questioning needs to stop immediately. If the subject waives their rights, then the questioning can continue. Silence about the waiver is not going to be presumed, and the burden is on the state to show that silence is a waiver. Harlan here was a concurrence which says that the right is not supported by the Fifth Amendment. Instead, the only test should be the voluntary or involuntary coercion test based off of the previous cases that we had talked about in our last episode, and that those were sufficient to provide enough protections to the defendant. White here argues that a waiver is not a good solution because a waiver may also be coerced. Because if you're concerned about the police being coercive and that's why you're having them read Miranda or potentially waiving the Miranda rights, well then why are you going to require say that it's fine for the defendants to waive their Miranda rights in the police's presence, which may be that same coercive environment that Miranda is trying to solve. Okay, a couple of other notes related to Miranda. So considering Messiah and Escobedo, Miranda could have easily been a Sixth Amendment right, but the court still saw the need for police activity, and because of that, it framed it as a Fifth Amendment issue. Question: was Miranda a liberal or conservative position? Was it a conservative or liberal outcome? On its face, the opinion appears pretty liberal because this is a desire for attorney involvement pretty early in the case, and it focuses on the individual rights, and it also focuses on a pragmatic rather than a textual constitutional interpretation. As White says, there's nothing in the Constitution that says you have to read them their rights, and so this is a pragmatic rather than textual constitutional interpretation. But this opinion can also appear pretty conservative because it allows confessions by focusing on the Fifth Amendment rather than the Sixth Amendment analysis, and it provided an easy formula for admission. It's if you read these 4 things, if they waive that right, well then you're good to go. It's pretty much going to be automatically admitted. Let's talk about Dickerson versus United States as well. There was a statute in 1968 that came out and stated that voluntariness was the only test to admit confessions. In other words, there was no need for a Miranda warning. This case, Dickerson versus United States, says that the Miranda warning is constitutionally mandated. It must be given even if Congress disagrees. The end result of Dickerson versus United States, Miranda's not going anywhere. Miranda warnings are here to stay. There's going to be no doubt about that. Congress cannot change that. Okay. There's one part of the Miranda warning that I want to point out. Besides the rights that you need to read, specifically the right to remain silent, the notification that anything you say can or will be used against you, the right to consult and have an attorney present, and the right to have an attorney provided if you can't afford one, I want to mention when a Miranda right needs to be provided to a defendant. It says if it is stemming from a custodial interrogation. So those are 2 terms right there, custodial and interrogation, and we need to define both of the terms. Let's start with custodial. What is custody? The custody requirement. How do you know what one person is actually in custody? Well, if they're arrested, they're clearly in custody, but can that custody be earlier than an arrest? Can it be at the same as a stop? Does it have to be later than a stop? Is it kind of like this in-between stage? And the answer is yes, it is this in-between stage. So we have a case here, State versus Elmar. If in custody, then the rights need to be read before interrogation occurs, because that's exactly what Miranda says. A suspect is going to be in custody when their freedom of action is curtailed to the degree associated with the formal arrest. This is going to be an objective test. It's going to consider the time of the custody, the place of the custody, the purpose of the interrogation, who else is present there, the tone of the voice of the interrogator, the response to the subject's answers, whether the subject is free to leave, hint, hint, there's a stop, and some other things. It is important to note, though, that age is not a factor to determine whether or not an individual is in custody. If there is a finding of custody at any one point in the interaction, well, then this will extend to any police interaction, regardless of that time barrier. Also want to point out that consensual police interviews are not custodial. So we talked about the different levels of police interactions. You've got a consensual conversation, you've got a stop, and then you've got an arrest. A consensual conversation is not going to be custodial. And then custody is somewhere between a stop and an arrest. You're going to consider those factors. So let's look at a couple of examples. We have State versus Turmel. Turmel was pulled over after he was observed through the window with possession of illegal drugs. He was asked about the drugs when he responded yes. Before he put... Sorry. All right. So Turmel was pulled over, and he was observed with illegal drugs. He was asked about the drugs, to which he said, yes, I have drugs. And he said that before he was put into the back of a cop car, and after he was put into the back of the cop car, the officer searched the car and discovered the drugs. So was the person in custody when the officers asked, do you have drugs in the car? And because if he was in custody at that time, well, then the police needed to read his Miranda rights before asking the question, because he would have been in custody. Well, this was a stop. but it's not within custody, so there's no need to read the Miranda rights here. He wasn't in the back of the vehicle yet. The police had just asked a confirming question, so on and so forth. Then we have State versus Dyer. In State versus Dyer, the officers responded to an emergency call at Dyer's residence. Mrs. Dyer was removed from the residence to receive medical aid, and Mr. Dyer admitted to hitting Mrs. Dyer. When Mr. Dyer attempted to go to the back room and to conceal himself in the back room, and Mr. Dyer indicated that if anybody followed him into the back room, there would be gunfire, meaning he would either, I'm not sure what exactly that means. He's either going to shoot at the officers or shoot at himself. When he made this statement, the officer stopped him from going into the back room. So, is this restraint on the defendant a custodial restraint on the defendant? Well, the court said the defendant here was in custody because the effect on the suspect, because his desire to go away demonstrates that he felt he was in custody. He wanted to leave, and so the officers restrained him from doing that, and the effect of that meant that he was in custody. This is a close case, though, and it demonstrates that more warnings are better. If you have a question of whether or not there needs to be a Miranda warning, just give the warning. Okay, let's talk about the interrogation definition, the definition of interrogation, because if you are in custody, but you're not interrogating the defendant, well, then there's no need for the Miranda rights there either. So Rhode Island versus Innis defines interrogation as express questioning to the defendant or words or actions on the part of the police that the police should know or are reasonably likely to elicit an incriminating response from the suspect. In other words, this is the functional equivalent of express questioning. This second prong, the words or actions, this functional equivalent of express questioning, it focuses not on the intent of the police, but the potential susceptibility of the defendant, considering whether the defendant is anxious, disoriented, upset, or any other factors. There are exceptions, of course, to the Innis rule. The Innis rule. Let's just look at the Innis rule a little bit more carefully too. Express questioning of the subject is pretty much a given. If you are talking to the subject and they're in custody and you ask the subject, "Hey, did you do this?" That's going to be an express question. That has a question mark. What about a functional equivalent of the express reasoning? Well, we're going to look at the defendant's state of mind, and we're going to see if the police are reasonably likely to elicit an incriminating response from that suspect. If that's the case, well then a Miranda right needs to be read. There are exceptions to this Innis rule. You have routine booking questions. If the officer is asking standard booking questions, then there's no need to read Miranda rights. You can find that in Pennsylvania versus Muniz. Interrogations by undercover cops. Miranda is all about coercion at the station, so undercover questioning does not cover those discussions with undercover cops. And that's illustrated in Illinois versus Perkins. And then also for public safety. Public safety is the third main exception to the Innis rule. All right, let's talk about Commonwealth versus Diaz and Commonwealth versus Sepulveda. These are two examples here of interrogations. In Diaz, a suspect was being fingerprinted when he exclaimed that this finger process would incriminate him. He was asked why, and the suspect admitting to holding the gun in question. All this was done before Miranda rights were provided. This is an example of an express question, but it was done during a routine booking practice. So, who's going to win out? An express question or a routine booking practice? Massachusetts here, the state where this was at, said that this was not a custodial interrogation requiring a Miranda warning because the initial statement was spontaneous and it was unprovoked and the question was a natural response. Underneath Commonwealth versus Sepulveda, what happened there is that the officers received a 911 call saying that a woman was being dragged into the neighbor's home. The officers knocked on the door, they noticed blood on the porch, and then they arrested the subject. Before giving a Miranda warning, the officers asked, "Where is she?" In response, the subject said, "I shot them." This was an express question, but it was done for public safety, and so the statements are not going to be suppressed. One other thing that I want to talk about Miranda warnings is that the precise language of a Miranda warning is not given in Miranda. You have to tell them those 4 things, but it doesn't tell exactly how you need to share those 4 things. That means that there is some flexibility, and there are several forms that might seem a little iffy but have been found to be fine Miranda warnings that do not violate that rule at all. I just wanted to mention that the form of the warning doesn't really matter as long as you can properly give the 4 rights that the defendant is going to have. Okay, well that's all of this material as far as Miranda warnings go. Initial Miranda warnings, we have a lot more things to talk about. We've got invoking Miranda rights or waiving Miranda rights. We've got the effect of invoking Miranda rights. And then we also need to compare this stuff to the Sixth Amendment rights. But those are all going to be discussed in different episodes. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.